Welcome, and we're thrilled to hear and engage a discussion with you this morning. My name is Gus Chin. I'm a municipal judge from Utah.
Good morning, the Findlay Trojans, and congratulations on making it to the national finals. My name is Matt Gutwein. I'm your neighbor next door from Indiana, and I am retired, but I previously taught constitutional litigation and civil rights at the Indiana University Maurer School of Law, and looking forward to the conversation today.
Good morning, Ohio. I am Anna Terry Flores. I am a former state senator from Miami, Florida. And when I was back in high school, way back when, I participated in the We the People program in Unit 5. So good luck today. I know you all will do a great job.
Would you please introduce yourselves?
My name is Ethan Ernst.
Hello, my name is Saki Valsar.
My name is Rowan Chenevy. My name is Ethan Badnarik, and our teacher is Mr. Dickman.
Lovely. The question is number 2 and reads as follows. Quote, a Bill of Rights is what the people are entitled to against every government on earth, general or particular, and what no just government should refuse or rest on inference, unquote. Do you agree or disagree with Thomas Jefferson? What are the advantages and disadvantages of a national Bill of Rights as compared to state bills of rights? What are the differences between positive and negative rights, and which are more important to the preservation of liberty? You may proceed.
Mr. Chairman, I agree with Thomas Jefferson that the people are entitled to a Bill of Rights in order to protect their civil liberties and to facilitate a limited government. Bills of Rights provide citizens with important checks to the government's power and prevents the government from becoming tyrannical. As Patrick Henry noted in his speech to the Virginia Ratifying Convention, that all rights, not expressly and unequivocally reserved to the people, are impediently and incidentally relinquished to rulers. Declarations of rights also create important checks on the judicial branch, preventing judges from making rulings on people's rights based on their own whims and wishes. Thomas Jefferson wrote about the Supreme Court justices in a letter to Madison. What degree of confidence would be too much for a body composed of men? A Bill of Rights creates guidelines for courts to follow and provides an avenue to remove a portion of bias from legal decisions.
Mr. Chairman, in understanding the advantages and disadvantages of a national Bill of Rights in comparison to state bills of rights, it is important to note the U.S. Bill of Rights provides for a degree of uniformity and a set of minimum standards.
Mr. Chairman, the creation of the U.S. Bill of Rights in 1791 and the incorporation doctrine of the 14th Amendment in the 1925 case of Gitlow versus New York has in effect created a framework by which all persons under U.S. jurisdiction know how they are to be treated regardless of their location. The importance of this framework can be seen with the nationwide protests that occurred during the summer of 2020, where many individuals asserted their amendment rights of free speech, assembly, press, and petition in response to the death of George Floyd without having to wonder if it was protected by their individual state constitutions. In addition, it is important to note that in a system based on the rule of law, each person has expectations of a minimum standard such as their due process rights, and when those rights have been violated, the government or its agents bear responsibility, as in the cases of Derek Chauvin and 3 other police officers in the George Floyd case, rather than allowing for the Bill of Rights to become a parchment barrier, as James Madison had warned.
While the U.S. Bill of Rights promotes uniformity and creates limitations on both the national and state governments, state bills of rights allow for states to address issues specific to their situations, as seen with Ohio's inclusion of the Victims' Bill of Rights known as Marsy's Law. In addition, while all states address public education, the requirements range from providing a uniform system to Virginia's, which requires a high-quality system of education. Some rights have been created through an initiative process, as seen with 22 states providing a constitutional right to hunt and fish.
Mr. Chairman, the major difference between positive and negative rights relates to the idea that while positive rights assert rights that individuals should possess, negative rights place limits upon the government, which in turn provides for the preservation of liberty. While positive rights impose an obligation to provide an action such as food, housing, or education, negative rights are intended to prevent government actions such as infringing on basic liberties such as the free exercise of religion. It is important to note that positive rights, while idealistic, are often very difficult to enforce, as seen with the right to rest and leisure found in Article 24 of the Universal Declaration of Human Rights. By using negative rights, such as the Fourth Amendment's protections against unreasonable search and seizure, liberties can be preserved by limiting the government from intruding into our lives. This was shown in the case of Mapp versus Ohio, where it was decided that evidence which was obtained from an illegal search was not permissible to use in the court. And we are now ready for your follow-up questions.
Thank you. You suggested that in formulation of a Bill of Rights, it serves as a check on the judicial branch. At least that's the hint I got from your opening remarks. Do you think that the court has always gotten it correct in its interpretation of the Bill of Rights?
Mr. Chairman, I don't think that they have always interpreted the Constitution correctly. A good example of this would be in 1939, Minersville versus Gobitis, where there was a Jehovah's Witness child that refused to say the Pledge of Allegiance in their school. And the Supreme Court ruled that the school had the right to force the children to salute the flag. But then just 3 years later, in West Virginia versus Barnett, the court had almost the exact same case with a Jehovah's Witness child refusing to say the pledge to the flag. And they decided that requiring students to say the pledge actually violated their free exercise rights found in the First Amendment. So no, I don't think that all courts have interpreted the Constitution correctly. I would also like to add on to what my colleague has said and note that for the first 150 years of our country, the Constitution did not protect the rights of African American citizens as much as it did other races. And we see this with the Dred Scott decision, where slaves were ruled to be property. Which is obviously a horrible miscue with the Supreme Court. And in ruling that, they basically disenfranchised an entire group of millions of people. So there are also deeper foundations of this misuse of the Bill of Rights.
Thank you.
So the court over the years has recognized individual rights that are not found in the plain language of the Constitution. For example, relatively recently in the Obergefell case, the court recognized a right for individuals of the same sex to marry. When and under what circumstances is it appropriate for the court to recognize rights that are not found in the language of the document?
Mr. Chairman, I think it's important for the Supreme Court to decide new rights when the rights come into conflict between different states. For example, the right to marry between same-sex couples was very inconsistent throughout the country, and it was needed at that point to make a uniform system through our nation.
Right, but we certainly don't have a uniform system with the right to education. You already mentioned that, right?
I would say that's mostly because in San Antonio Independent School District versus Rodriguez in 1992, it was decided that education was not a fundamental right found in the U.S. Constitution and that it should be left to the states. So I would say that education is inconsistent through the United States because states individually have the ability to regulate how they want to deal with it.
Right, but they could do that same thing with marriage too, correct? Individual states could decide whether they're, under their constitutions, they want to allow people to marry or not of the same sex.
Mr. Chairman, that is correct. And that may be the right thing to do on these more controversial topics, because it would be hard to get a controversial topic such as same-sex marriage passed under federal law so it applies to all of the United States. It's easier to get these issues passed under state constitutions and get it going state by state until it can be passed as the whole United States.
Mr. Chairman,
Any other thoughts about when the court should recognize rights that are not explicitly in the language?
Mr. Chairman, I would like to add that through the use of the Ninth Amendment, we have discovered almost a reservoir of rights that when become things that are valued in the social aspects and the societal intrication of our existence in America, we can pull from this reservoir of rights that can be implied through the Ninth Amendment and write legislation and determine rulings based on that.
Senator?
Thank you.
Yep, great. So you all, someone mentioned the George Floyd, the protest this summer in response to the killing of George Floyd, which leads me to think about, are there times at all when there should be any sorts of limits on the First Amendment or on any of the amendments on the Bill of Rights? We've seen that there have been some laws that have been proposed that some argue are in response to that. So at what, if any, limits should be allowed on the Bill of Rights, and how should a court determine when we can infringe on those rights and when can we not?
Madam Chairman, while the First Amendment right of free exercise is very important, there are certain time, place, and manner restrictions that have been implied. And as seen with the George Floyd case, many people were breaking into stores and harming businesses around the community. And in that case, it would be a manner restriction where people are not allowed to do certain things that would harm other businesses or harm the economy. Some other restrictions would be hate, obscenity, or defamation, and certain other restrictions have already been implied over the years.
Any other times are there some times where it should it should not be okay? I mean, I think this is a topic that we're seeing across the country now. If about when there are laws. So in Florida, for example, there was a law recently proposed that some argue would limit free speech in certain cases. Courts may soon have an opportunity to give their thoughts. So what would it be the court's reasoning on determining whether or not a law is constitutional that is purported to limit, say, the types of gatherings and then, those type of things? What would be the court's reasoning?
Madam Chairman, I believe that the court would have to look at weighing the interests of the state, the secular and unbiased interests of the state with the individual rights that people possess. I believe that the courts have to maintain a reasonable balance between these two issues, because America was founded on the basis of individual rights, but through those individual rights need to be protected with the secular unbiased interests of the state.
Time. Thank you very much.
Thank you.
Great job, Ohio. Really, very nicely done. And now the judges will give you their feedback. Thank you.
Thank you. Very well done. I appreciate your opening remarks and the depth and the approach you took. I particularly appreciate the response you gave to the follow-up, particularly where we seem to defer sometimes to the decisions from the bench, but I appreciate how you went back historically and noted the disenfranchisement of certain members of the population with respect to various decisions, and also women's suffrage, clear example where the courts could have much earlier made an important determination that disenfranchised women for many years as well. So very well done in terms of your arguments in response to our follow-up. Thank you.
Yes, I agree. Wonderful job. Absolutely terrific. Your opening statement was sweeping, starting, with Patrick Henry and going all the way up to Derek Chauvin and George Floyd, covering, over 230 years of history in a brief period, recognizing the importance of negative and positive rights. And then terrific job in answering our questions. Great reference to the Millerville decision. Dred Scott nailed it with Dred Scott. I loved your comment about the Ninth Amendment and the Rodriguez decision. So very strong use of legal precedent, history, reasoning, current events as examples. So really terrific performance, and I hope you're very proud of yourselves, and I know your teacher's proud of you.
There we go. I could not agree more. You all did a fantastic, fantastic job. Your prepared statements were well thought, well reasoned. That's kind of to be expected. You have time to do that. But we gave you, some tough follow-up questions. And not only did you give your answer, but you didn't just say, well, this is, my gut that tells me this is my answer. Here's the reasoning of why this is the answer I'm giving. Here are some constitutional issues to, constitutional references and court cases to back up the reasoning that I'm giving. And I think that was a very good kind of an important step in not just saying, I believe this because I know this is the right thing. No, I believe this, and here's the reason that we can find and what we can find in our Constitution and in our court cases to back up my opinion. So I think fantastic, great job, and congratulations to your teacher. It was perfect.
Yes, and again, thanks so much to Mr. Dickman and the team from Ohio. Really have a wonderful rest of the day. And judges, I will be opening up your breakout room for you now. Again, thanks so much.
Good luck.
Thank you.
Well done, team. Wow. Relax. You'll have the rest of your Sunday is available for you. But I don't know what your tech problems were this morning, but it certainly did not slow you down. So you really should be proud of the work